sentenced, but your case isn't finished. Here's what matters next.
Being found guilty is not the end of your story. The sentencing hearing that follows can determine whether you go to prison or remain in the community, whether you face years behind bars or receive an opportunity for rehabilitation.
This phase of the process is often misunderstood, yet it's one of the most important stages in any criminal case. A sentencing hearing is a separate court proceeding that occurs after a conviction, whether through a guilty plea or a trial verdict. The purpose is no longer to determine guilt or innocence, but to decide the appropriate punishment. Unlike the trial, which focuses on the alleged act, sentencing looks at you as a whole person, your life, your background, your future, and the circumstances surrounding your case. In California, these hearings are usually scheduled a few weeks after conviction to allow time for a pre-sentence investigation and the creation of a report that will guide the judge's decision.
Before the hearing, the probation department conducts a pre-sentence investigation. This process results in a detailed report that includes your criminal history, a summary of the offense, and an evaluation of your personal background, such as your education, work history, family situation, and mental health.
The report also assesses your risk to the community and makes a recommendation about your sentence. This document carries a great deal of influence, and having input into the process through your attorney can help ensure it accurately reflects your circumstances. California follows a determinative sentencing structure for most felony offenses. This means the law establishes 3 possible prison terms, a low, middle, and high term. For instance, a felony might carry a sentence of 2, 4, or 6 years. The judge must choose among those options based on aggravating factors like violence or prior convictions, or mitigating factors such as a lack of criminal history or evidence of remorse. Misdemeanors are more flexible, but judges still must work within the maximum penalty allowed. Some convictions, particularly those classified as serious or violent felonies, may fall under the 3 strikes law, which can drastically increase the length of your sentence if you have prior offenses. The hearing itself follows a clear format. First, the judge confirms that both sides have reviewed the pre-sentence report. If there are any errors or disputes, your attorney can raise objections at this time. Then both the prosecution and defense present their sentencing arguments. Prosecutors usually emphasize the severity of the crime and any aggravating details. Your attorney, however, will focus on mitigating factors, things that support a more lenient sentence. These might include your lack of prior convictions, family responsibilities, remorse, rehabilitation progress, or hardship circumstances surrounding the offense. You may also have the opportunity to speak directly to the judge. This is known as a statement in allocution. If done properly, it can have a powerful impact, humanizing you in a process that often feels impersonal. This is your moment to express responsibility, acknowledge any harm caused, and explain how you plan to move forward. Mitigating factors can make a significant difference at sentencing. Examples include minimal involvement in the offense, being under extreme stress or emotional duress, having no prior criminal record, showing genuine remorse, being willing to pay restitution, having community or family support, holding steady employment, or struggling with mental health or addiction issues that contributed to the conduct. A skilled attorney will not only identify these factors, but gather evidence, letters of support, employment records, treatment reports, and present them in a way that resonates with the court. It's also important to know that sentencing doesn't always have to mean jail or prison time. Depending on the offense and your background, alternative sentencing options may be available. These can include probation, split sentences, house arrest, community service, treatment programs, or electronic monitoring. These alternatives can allow you to keep working, care for your family, and address underlying issues while still being held accountable. Having strong legal representation at this phase is absolutely essential. Your attorney can challenge errors in the pre-sentence report, highlight critical mitigating information, and push back against exaggerated claims by the prosecution. They can also help you prepare a compelling personal statement and negotiate for alternatives to incarceration. Even if a conviction was unavoidable, the sentence that follows is not set in stone. A well-prepared defense can lead to a dramatically better outcome. Sentencing is the final stage in a criminal case, but it doesn't have to define the rest of your life. With the right strategy and advocacy, it can become an opportunity to show growth, accountability, and a commitment to change. Your future is still in front of you, and with the right guidance, you can take control of it. Subscribe to our YouTube channel for more insights on how to protect your future and move forward with confidence.
Don't forget to like and share this video, and for more legal insights, keep watching and subscribe to our channel.